information that I want to disclose in support of the motion today, then the court should conduct procedures in camera. Now, is it necessary for me
scram plates, scram
to
first.
report
Okay.
what
All right,
my
Owen.
prejudicial information
See you
is?
soon,
The
friend.
media says in their motion
3 weeks, clear trial.
that they filed yesterday, which is, I don't think I have a docket number for this, but it's entitled News Media's Memorandum.
It's a lot of drama, man. A lot of drama, you know?
Which is filed on the 12th yesterday. I don't have the docket number, but I'm sure the media does, if there is one. But what they say is it's really not necessary.
Hi, what's up?
All the
What's up? You got something with us today?
No, I was looking out for another client.
Thank God it's Friday, huh? My goodness.
Page 2, they say, if the defense does not want to highlight certain information at the evidentiary hearing, it can choose not to.
I don't want you to
The
inspire.
information is already cited in the motion to exclude.
Do you say roller coaster weather?
The court should find it.
Do you see what happened yesterday on the news?
That would be a good
There's
solution,
I
except
think
for
it
the
was
fact
like
that the
in,
media is also
it was in
opposing
Ohio.
our
There's people
request
go on a roller
to
coaster
keep the
and
motion.
there's a 13 or 14 or 15-year-old girl behind,
So it doesn't.
and it's a 78 mile an hour roller coaster, and
all
the theme goes
prejudicial
up.
information in the motion.
So they literally, the two people in front are holding her in as they're going in this roller coaster, and the roller coaster going 70 miles an hour. They're literally holding her. She's yelling at the top of her lungs. Can you imagine that?
And they're gonna-
And the roller coaster, like,
all the highlight
they
prejudicial,
had 20 malfunctioning seatbelts earlier in the day.
and
And still been going.
You know, just, I mean, and my son,
other points.
and my son loves these roller coasters. I'm like, here, look. Woo. I mean, just, man.
Present motion.
I mean, you know, but it's bad because a lot of times you feel like you have a personal injury case. It's usually the client who's like, I can't make it to the doctor. I can't get it. And you're like, bro, you got the bag. Always $1 million, the case that I could semi-retire on for the client.
Yeah, I know. Straight.
Well, Judge, you gotta get rid of this docket.
I know, we're trying, I know.
Great seeing you, guys.
Great scene. Hey, you ready? What you got?
I've got a Brady or Christina Brady. It's in the docket for a payment in custody.
Do I need to bring her out?
I'd like to hear PC. I don't know if you can bring out PC.
No, let's just do PC real quick. We got a lot of stuff that we still need to do.
On August 4th, 2025, police officer was dispatched to a house located at 1130 Dana Drive within Harris County, Texas, regarding to a family. Complainant is defendant's elderly aunt who is 75 years old. Complainant stated that she has been allowing defendant to stay at her home for the past 1.5 months. Complainant stated that defendant got upset after complainant tried to talk to defendant about cutting back household expenses. Defendant yelled at complainant and approached complainant while holding a large glass cup. Defendant then threw the glass cup at complainant, narrowly missing complainant. The officer described the glass cup as one that was made of thick glass and had some weight to it. Said glass cup was about 5 inches in length. The officer said glass cup is a deadly weapon capable of causing death and serious bodily injury.
I mean, death is a stretch. I mean, but so did she get cut? What happened?
She narrowly missed.
She missed.
The complainant is 75 years old.
And of
Oh,
course, it's,
does that play?
I think it does play a factor, but I say first, it says the person walked up and threw it early this morning. I can understand why they're trying
Let's
to.
hold on. Let's read the statute because let me pull it. Hold.
Media stressed to the court.
Recklessly engages in conduct that places another in imminent danger of serious bodily injury. A person intends to be knowingly discharged with a firearm. That's not ours.
No, I think it's under.
Through
A, recklessness and danger are presumed if the actor knowingly pointed a firearm. No, that doesn't.
Or motions to extend
If the glass cup did hit the and judge, it would be an ag. That's all. Because we get a beer bottle at Amazon.
And I understand a beer bottle and all of these things, possibly, maybe.
But it didn't, though.
It didn't hit her.
Right, that's why it's not upstairs.
I don't-
Because if it did.
Would it not be an attempt?
No, because if it did, no, because we don't normally, charge attempts like that, Judge. I work and take
In terms of the
a lot, and we normally go either the ag assault route or the death conduct route, Judge.
So I guess the question is, does the
which is 511.
complainant have to suffer a harm for this charge
Rehnquist
to
writing for the court.
stick? You know what I mean? Because I think that, are you alluding to the fact that she didn't get injured as a result of that?
You're alluding to that fact. I'm alluding to the fact, first of all, it has to at least be reckless, right, of your men's rap. First of
If
all,
you're throwing a cup at someone, it's a glass and she's 75 years old.
claiming it through the cup. I mean, honestly, right, if I walked up on you, if I wanted to hit you, I'd just hit you with the cup, especially at 75, you're not getting out the way. I don't know how agile he's 75.
Well, I'm not gonna, I mean, we're not gonna.
She just throws a cup and, out of anger or whatever, she's not, they say narrowly discerned, these are just facts, and I'm sure that's for a jury, but do I think it's truly deadly conduct? Do I believe this person believed that, hey, this cup was
That's not, but it says here, imminent serious bodily injury. If you throw a cup at someone, it's glass, like it's the eggshell plaintiff,
I absolutely under that, but even, I think eggshell plaintiff typically goes to civil court, so I don't.
I know, but I'm saying she's 75 years old, man. You throw a glass cup that's thick as hell at her cranium, what's gonna happen?
We don't know how thick this glass cup is.
Well, you said it was thick?
It calls
It was described as a big glass. A big glass.
Police officer
That's
described.
I think there's enough. Sorry. Yeah.
You already want to try to understand.
We're not that far.
I think I-
Yeah.
Sorry. I think I-
Yeah, come on, bring it. Let's go.
Excuse
Page 9 and 10,
as
Jackson's
it's
first initial day.
are knowledgeable. Read this media coverage. It excludes the evidence.
Are all these people late?
Minority groups, women, and people that normally would be included in a representative jury. So, yeah.
Sir, you were charged with 2 counts of failure to stop and give information. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
You're going to be excluding a large portion.
On March 1st, 2026, officer in Harris County, Texas, was dispatched to an accident. And advised she heard a boom and realized one of her motor vehicles was partially inside her living room.
Inside her living room.
Yes, Your Honor.
Holy moly.
She ran outside and saw multiple motor vehicles in her driveway had been damaged. Complainant observed defendant.
Hold on a second. Did she give an attitude? Come up here. Come up here. You've been giving attitude all day, man. Take a seat in the jury box.
Other means, they come with a great cause.
Don't get taken feet down.
The
But
Constitution.
you ask, you don't just tell them, come go to the restroom.
Main
Or
points.
wherever.
You can take her back.
Oh, no, to the restroom.
Certainly happy to answer any questions.
Man, no more drama today. No more drama. Please.
Defendant ran outside and saw multiple motor vehicles in her driveway had been damaged. Complainant observed defendant exit the motor vehicle and flee the scene on foot without providing any information.
So after he bangs into the house, he takes off?
Yes, Your Honor.
Okay.
And then there's a second complainant who stated he heard a boom, then observed defendant exit and flee the scene on foot in his motor vehicle which was a primary motor vehicle struck by defendant. Complainant two observed defendant enter a nearby residence and he waited for officers. Officers made contact with the defendant who stated he was leaving to go to the store when his glasses fell, and while reaching his foot hit the gas, causing him to collide, and he left the scene because he was
That's the
scared.
motion to classify the reply brief
Okay.
in support of the motion.
Does he have a license to drive?
Yes, Your Honor. It's
Your Honor,
helpful.
like that.
Okay. Mr. Jackson, I'm ordering you not to drive at all. If I find that you do, I will revoke your bond on both cases and I'm going to put you in jail. No more PR bonds. This is not a revolving door. Do you understand?
Trial. First is the January 9th motion. Then we've got a motion to classify the motion to exclude cameras, which Mr. Burke.
How old are you, sir? Do you have the ability to hire a lawyer?
To classify the reply.
Okay, we will give you time. I'm gonna have you go to Victoria Center Reset. I'm gonna have you take your seat in jury box till we get your bond conditions. Once you sign them, you'll be free to go. Understand these are serious bond conditions and I expect you to comply. If you get out there and just think you're gonna do what you do, it's just not gonna go well for you.
So it's my
Comply with
understanding.
it. You understand? Okay, come on. Yeah, no driving.
To those motions.
No driving.
Yeah. Are you ready? THA and then states conditions, no driving.
Okay.
Page 23.
Hey,
Not supposed to have. The state's opposition is.
what is her last name?
Ferguson.
What's she gotta do? Sign bond conditions?
Yes.
Okay, let's get her up here so we can get her out. Miss Ferguson, come on up.
The state's opposition is docket number 31.
Judge, I don't think they were filed.
And then on the motion to close portions of a full hearing, the state's opposition.
Oh, hey,
I think.
they're with Veronica. It's no drugs, no alcohol, random testing. And this is the one where we're waiting for next week or what?
The media.
So just Veronica, can you take care of her so we can get her out?
And that lists all of the docket numbers of the relevant.
We're gonna have you sign bond conditions and then we're gonna see you next week.
Hopefully
If you act up like this again next week, it's not gonna go well for you. There's a certain decorum in the courtroom. When we start acting up, it just doesn't go well.
the standards that
Please.
apply to these two different categories of motions.
No, you have to sign your conditions. We're gonna give you a reset and then you go.
About articulating and applying the correct legal standards that govern these motions. Because there are different standards that apply to classifying documents.
From the magistrate, Mr. Brandon, there's this thing that there's on the firearms. Did you want to keep those?
Yeah, just keep those. Yeah.
To classifying
Yeah,
documents.
that's the next one.
Down in the administration. That's where-
I wanted to just approach again on Brady for bond.
Okay.
I wanted to speak to her first. I had just saw the last cup, so I can't, but, you know.
And
I-
the standard that applies to closing.
But Ms. Brady did let me know that she does have another place to stay with her friend. She is a longtime Harris County resident. For her whole life, she went to Cypress High. She lived in Channelview. She says she's not working at the moment, but she does an odd job. She goes in, does some car washes, does some like work. So y'all,
So I want you to verify that she has an actual place to stay. Like, we're not gonna take her word for it. Like, you need to know where she is. And then if I give her another PR bond, she's gonna get an ankle monitor. She's been gone for like 300 something, let me see. Yeah, for 225 days. So,
this is the.
yeah, she's been gone for 220 something days. So,
Closing the hearing. Obviously, everything that's going to occur in the hearing is going to occur in court.
Dick, do you want to call up the next person?
Yes, Judge.
Come on.
Page 23, Wilson.
About a lawyer.
So as far as confirmation, you just
Information.
Like, so,
actual address.
like, so she should give you a phone number, call them and ask them, hey, can she really stay with you? You got a place to stay for her? Because I'm not gonna take her word for it and I don't want her out on the street.
Now, with respect.
Wilson, you say?
Yes.
Classify defendant's January 9th motion that has to do with the evidence. The state did mention Rule 3.6.
Good morning, Mr. Wilson.
So
Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or $2,000 fine.
state
We were
did
going to
not
do
because
probable cause. You have the right to remain
they
silent.
recognized
Anything you say can and will be used against you.
5.6
You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
evidence and testing.
On March 5th, 2026, in Harris County, Texas, officer observed a vehicle with no license plate enter into a gas station. A traffic stop was conducted and defendant exited the vehicle and was advised of the reason for the traffic stop. Defendant stated he did not have a driver's license on his person, but showed a picture of a temporary driver's license. Officer ran defendant's identifying information and his driver's license returned as not eligible.
Mr. Wilson, you're on felony probation. You're supposed to be living like you have a halo above your head. You've now picked up a new case. You are not allowed to drive. That is a bond condition of yours. I don't care what you got to do in this life. You want to drive, go get a license, get insurance. But until that point, if I find that you do, I'm going to put you in jail and I'm going to make your bond high. Do you understand? You will be signing an affidavit. This is a promise that you're going to make to me today that you're not going to drive. I don't care that you need groceries. I don't care that you got to go to school. I don't care that you got to work. If you don't have the proper license, don't do it. You must get approved from us first if you get it. Do you understand?
Now, another thing I want to clarify is we are not media lawyers.
You have the ability to hire lawyers, sir.
The media.
Do you have the ability? How are you supporting yourself these days?
Our client is the people of the state of Oregon who do have
When is the last time you've had a job?
the public nature of these proceedings. But whether any particular document is public or private of secondary concern.
In and out,
We're not trying
and
to represent
in
any
and out,
media
and
interest,
in
and
and
I think it's improper for the defense to suggest that.
in 3,
Although maybe the media might
2
hire,
short years.
we probably
1,
judge
2,
who are
3,
the
4,
media's lawyers.
5, 6, 7, 8,
We're not
9,
representing the media's
10,
interest.
11,
We are
12, 13, 14,
primary
15,
is
and now
this case.
16 in a matter of 2 to 2.5
So with that, let me
years.
turn to the substance of our response to the.
What do we need to do to protect our
It's clear
Mr.
from the rules of judicial administration that document, having been filed with the court, is a presumptively public document. And a general allegation that it discusses evidence that might be inadmissible is not enough to deny public access.
What do you think?
If that were enough, then any.
What are appropriate conditions to place on a 16th case within 2
And even
2.5
basis
years?
ultimately finding that the evidence
The driving, Your Honor, the drugs, no alcohol,
discussed in the motion was inadmissible.
just to make sure he's monitored.
Exposure to that kind of evidence does not necessarily justify
Driving while
or it does not necessarily prejudice defendant's right to a fair trial and justifying sealing that document. And the controlling case of State versus Allgaier here from the Utah Supreme Court in 2011 is very instructive on this point.
Take your seat from the jury box.
It's instructive to all of these.
Judge, yes, today the meeting,
Capital
at the time of the state is
and
requesting a GPS to be placed on the defendant's phone.
What time of day or night was this? Was this in the middle of the night?
It happened at, it was 11:30 at PM.
Or- Yeah, I think that you're probably,
and
Thank you, thank you, Judge.
and the
okay.
other
Carl, Kavita, you ready? Do we have one more?
review of that confession. I can't imagine any more powerful
Coming up, ma'am.
It's a clear admission. Clear admission.
Ms. Remsen, you were charged with driving while intoxicated. You're also charged with terroristic threat. The agreement that you have worked out is they're going to dismiss the terroristic threat in exchange for your plea. You need to understand that this DWI will go on your record. It will be there for the rest of your life. Every time you get pulled over, officers want to know who they're dealing with. They're going to see this. If you smell like alcohol or dope, what's going to happen?
It is relevant to.
You need to be on notice for the rest of your life. Every time you get pulled over, they're going to look you up,
In
smell like alcohol or dope, and they see a prior DWI.
to release that letter
You understand?
is really
If
instructive.
I were you, even if you have a sip of alcohol, don't get into a car.
Already
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, it will go on your record. You can never take it off. You understand?
And I
From
think
now on, what we're doing,
the court said those
it's a minimum of 30 days in jail from now on. There are no more proverbial slaps on the wrist. Do you understand? How do you plead to the office? Guilty or not guilty?
So prejudicial.
I'm going to find you guilty, sentence you to this agreement. I'm going to suspend your license for the minimum, which is 90 days. Do not drive until you get a license, and good luck.
Restricting access.
Yeah.
That.
Thanks. Please see the clerk. Oh, we're Twinkies. That's so sweet. Have a great weekend. Counsel, you ready? No? Close. Did you find a place?
I did.
And call verify?
Called it verified. It's her uncle. His name is Mr. Earl.
Okay.
Mr. Earl said immediately she could stay and he would come.
So we'll do a GPS prior to leaving. Let her know it's never going to happen again. No, it's a deadly, so no contact with the complaining witness, no weapons, and then, we'll give you a couple settings, an old case, so it won't hold open forever, but, okay. So just let Veronica know, or you know what? So Veronica, on Miss Brady, at GPS prior to release, no weapons, no contact with the complaining witness, and then stay in contact with the lawyer. No waived appearances, so she's got to be here at the next setting. It's old. Okay, counsel, yes, ma'am.
Good afternoon, Judge.
Hi.
I'm here on Mr. Alexander.
You've been waiting ever so patiently. Alexander, okay.
So, he was hospitalized, from the day that, he was supposed to, the day before that he was supposed to have a negative test for Lyme condition, all the way until the 11th. I think he got discharged yesterday.
Is he here now?
He is here. He
Okay.
has already taken it. He went down.
I don't know that it necessarily works that way. I think that.
But he's been hospitalized.
The fact that media coverage.
Is he under, like health or mental for
No,
hospitalization?
he had a physical.
Okay, got it. Okay. So even if he tests positive, I'm not going to do anything yet. I usually give him about 50 days, but let him know that this is not forever.
Because the question. And I also point out that not all.
That's not good.
In this case.
Did we order no alcohol, no drugs?
Favorable to the defendant and favorable to the state. It's gone both ways here.
So here's what I'll do. I'll put a scram on him now.
So just saying.
Any further violations, he'll stay with me.
Content toward.
Let him know.
This is his,
Where there's been a barrage of media coverage.
and there may have been some confusion when his bond conditions were signed about that.
Did I put that condition on, or did Magistrate put the bond condition on?
When I had gotten the point, I think.
If it was me, it's usually for a reason, like usually alcohol is a factor in the case.
I understand, Judge.
And I
By
put it
the
on.
time that you did.
Court hearing, the court has to.
Is it alcohol a factor in the criminal mission?
I'm taking a look right now, Your Honor.
And it's
This
first
was,
of all, that there's a
this was given,
that type of proceeding.
it looks like it was by, maybe this is instructed by our sentence.
Yeah.
There's no presumptive right of public access because he
Taking a
has,
look at it right now, Your Honor.
instead he's assumed.
Come up, Mr. Alexander.
Public access and has argued for the court to close that hearing. But again, defendant has has incorrectly relied on the standards that govern classifying documents rather than the standards that govern closing a court proceeding.
There's
And
no allegations in this case regarding any drug and regarding any alcohol, Your Honor.
Any,
the same argument
anything with
legally apply.
Any illegal substances then?
Have to show that the closure is
I
necessary.
guess read me the DIMS real quick.
Yes, Your Honor.
File. And of course.
On February 6, 2026, in Harris County, Texas, officer was dispatched to a criminal district call when it advised that he was inside his motel room. When out of nowhere, the suspect banged on the door / window aggressively, bending the bottom of the door to where it was unable to be locked. The cost to fix the door was $650.
Okay, I'll take it off.
Thank you, Judge.
Yeah, okay.
Your Honor, I would.
Public.
His hearing.
I know, but you know, it's not, it's, if it was something that were a factor here, then I would agree with you. But when you over condition, it doesn't do any good, you know, really. We have enough drama as it is. We don't need any more. Just don't pick up any new cases. You understand? Okay, man, take care. We'll address, just let her know.
Thank
We'll
you.
take off the no drugs, no alcohol. rating test, Okay?
Thank you, Your Honor.
Waiting around for this.
I need her to read the law, because she's married. Mr. Ball.
Media reports that have created concerns about personal privacy and safety.
Yeah. So, I mean,
See, I don't know where the statement for that, when they said you didn't have an apartment, most recently, when I said for that, it's still an apartment.
And
It does.
Okay.
that implicate
The
personal.
other end of the document, the apartment.
Closed.
He may not have been looking at the amended protective order, but the amended protective order does have the apartment number on it.
Is this in all?
That's correct.
Okay.
Okay, Judge, I'm gonna be the only person handling this case. Apparently, there's been an indication that I have lied to the defense attorney.
no, there's not. There's not. No.
Letting the prosecutor touch this, if this.
But there's not.
It could be a very common thing that is thrown out, so.
It's not.
I
It's
am
not.
prepared.
By people, what do you mean by that?
No,
Yes.
please, it's not a big
Yes.
deal. I think that there's a lot of confusion because
And
we don't know exactly where she is. And as you can guess, when reports aren't written in such a way where we can pinpoint exactly where someone is in relation to the apartment, tension can run high. So,
the January.
But
is she within 200 feet?
I believe that she is based on Google Maps. If you look at any handicap parking spot in the apartment complex and go to the furthest point to the middle of the street, it is less than 200 feet.
7.
So if she is at any handicap parking spot, if the apartment is as far as the street view on all of the apartments, she is still within 200. In the body camera, she says that the defendant drives on the outside of the street, which is closest to her apartment, that would be within 200 feet. She pulls into the apartment parking lot and parks in a parking space, which would still be within 200 feet.
So I think the argument they just made is, so for example, whole apartment I used to live in off West Belford at Buffalo Speedway, you drive past West Belford, you turn into the apartment, and then you have to be away. Is that the argument they just made, that she drove by?
According to the body
Even,
camera.
even where she is in the apartment, where she pulls in the handicap space, she's still within the
And
200
my
feet.
argument is that she's not, because they don't know where the address, they don't know where her apartment is. They know the apartment number, but they didn't go to the apartment. They don't know which apartment is. Here's the thing, right? Again, I keep saying this, I think it's important. On the DIMS, they didn't say this. On the office report, they didn't say this. We're trying to look outside of that. She spoke to the officer.
But they can though.
Well, what I'm saying, and which is why I've been doing my follow-up, which is why we got to the body camera. She told, the officer told her that somebody complained with her that she wasn't in the apartment. I went, this woman goes to the body camera. I went to the body camera. That's not stated in the conversation on the front end at the 4-minute part or later on at the 40-minute part. I spoke to CW. CW made it clear. She did not go into the apartment.
None of that matters though.
But no, what I'm saying is, because that was a contention that the state made. So, and I'm also saying, we don't have the information here to say whether the apartment is. They have it where she was arrested for being at the address. And to your point, like you've been saying, that's incorrect. She can be at the address, because the order says 13.
I agree with you, but she's still within 200 feet. She's in the handicap parking spot is within 200 feet.
Your Honor, the state doesn't know that, the cops don't know that, and the cops didn't arrest her based off that information. The cops arrested her based off the idea that she was at the address, which is incorrect. That's my probable cause.
The
The
defense
cops-
also indicates the person was inside the apartment, and she said that she had, okay, I'm
It
sorry.
was very clear that this
My
was a
mistake.
substantial probability.
So the DIM says that she was in the apartment.
No, it says the second person was inside the apartment.
So that really matters.
That's what I had misread.
Judge
So
rule
now,
for
at the time they
dash
arrested her,
two.
they arrested
The
her
only
based
difference
off false
being that in
information. That's what I
Press
was
Enterprise,
saying.
clarified the standard is 16
Careful, careful.
this. And although that case was referring to hearings, open hearings and open court filings are just two sides of the same coin. They're stemming from
So,
the First Amendment. They protect the
Did they
same.
incorrectly arrest
So
her?
there really
And
is no
can
need
you,
for
I
court to
guess,
consider
cure that,
high
so to speak? I
standards.
mean, does it?
I have
Or
a
filing
request in to be put in a grand jury on Monday, so
it can really be that
I think we have
Press
sufficient
Enterprise 2 test.
on the.
Get indicted.
Whether you're
Well, no
only at
probable
Rule
cause is
4
Oh, I see.
202,
Right.
That's my only.
whether you're looking at Press Enterprise
So
2,
let them indict her, Your Honor, and
the
give us a chance to put in a
outcome for
package
this
to show
motion
them
in
what's in the
particular
district, because the
is
cops don't even know what a apartment is,
and
they
that's
didn't go
what
inside
Mr.
the
Ballard
apartment. They didn't
referenced.
do the measure.
Filings are
They're doing these guesses.
public,
This is also the
and
same
that
cop who
doesn't
said, yes,
change.
she went into the apartment.
Or
This is the same cop telling you 200 feet, is the cop who told her she went into the apartment. That's the same person. She didn't go to the apartment, plain when said it, but we're gonna believe this cop saying it's within 200 feet. Are we gonna believe Google?
But the only thing that really matters is she within 200 feet?
I don't believe she is, and I don't believe there's information, enough probable cause information to figure that out. And I don't believe the cops knew that at the time.
Admissible in the
But
court.
they have it on Google Maps that it is.
And then also
Yeah,
in the United States.
We know how Google works first.
Which is a case
But
cited by
is
the
it
court.
I gave
That's
it the most
119.
generous in the
806.
favor of the defendant measurement that I
Really
could
just the
possibly
final point I
measure.
want to make on this motion
And if
is
you cut across the
arguments
entire
are
apartment
about
complex,
why
from
this
the middle
motion
of the handicap parking spot
sealed
to the middle
really
of the
quite
street,
generic
it is
arguments
hundred and
about
twenty-six.
pre-trial evidence.
If
It could
her
have been
apartment
applied
complex
in
if her
any-
apartment is the furthest one, it's less than 100.
And I
You
understand.
can also change, she's on the third floor. There's so many things the way to get it.
I understand.
And all I'm saying is, they ain't know none of
The
this
arguments
at the time.
in sealed
The arrested
were
her
just
thinking
generic.
the whole apartment complex was all
Trial
and that
evidence.
wasn't the case.
And as we
That's
argue
what I
our
mean.
underlying.
They wouldn't be here arguing
On
this.
opposition,
That was
we
the
don't
case.
think
The
we
cops took a little bit more steps.
motion
They were trying to find a reason to take her in
justify
jail.
that this
To
type
be totally
of
honest with you,
evidence
this happened in
is
this case.
kept.
They're trying to find a reason to take her in jail because they believe she's.
So unless Your Honor
They
has
shouldn't
any
get to do their
questions
job.
about that motion to classify.
They said, oh, we want to raise the BPO and get rid of the situation.
So
They
the
think they
next
were
two
helping,
motions to
right? Because the
classify
sister called
are
because
relating to the motion
she's,
to exclude cameras.
said she was,
And
at
that
work, she was about
is
the kids.
docket
So that's why they
400,
arrested her.
that's
They didn't arrest her.
classified
And
the
I don't know why they
primary
did that, but they did not.
And then docket 400, which is motion to classify the reply in support of the motion.
I mean, do you have anything
And
to
the news
support
media
the position
oppositions
that
can be
if they
found
made the
at
arrest
docket
based
323
on
and docket 429.
maybe incorrect information,
So for these
they can
motions
cure it
in
later and it's
particular and the
okay?
reply, I just want to make very clear
I
that
don't know. I mean,
you cannot make.
they're arresting based on the fact that
private
they
by
think at
putting
the
it in
time that
court
she's just
filing.
not supposed to be at the location at all.
That's because
when in
filings are
fact,
presumptively
There
public,
is
but also
a
because again, the
protective
information
order
is
that says you
public.
can't be within
You
200
can't
feet,
take
but
a
she
public
is
thing,
within.
put it in a public forum.
So
and
the
suddenly
closest
it's
I have to
private.
it is Hyman, North
That
Carolina.
just is not how
That's
the
a
rule.
Supreme Court case
There has to be
where
some sort of
the
showing as to why this
officers
information cannot be
incorrectly,
made public,
arrested
but
somebody
again, it
for
already
a traffic
is
violation that
public.
didn't exist.
Including, in
And
fact,
because it
information
was
that was
actually not
created by
the
the
legal
public.
thing in which
So
the person they pulled over was
the motion to
doing,
exclude is
but then they found
private.
drugs later. And then
That's
the
saying to the
court said
public,
they
you don't
justified it.
have access to
Unfortunately,
information that you
for
would
the law
have
enforcement, in
created.
Texas, we have 3823. So you can't have an
Similarly,
incorrect,
the court cannot prohibit
incorrect
the
arrest
public
and then
from
try to cure it later.
discussing
That's the whole
information
point of
that
having
is already
3823.
public.
During
That is a
instruction,
prior
saying
restriction.
it codifies as you know.
If there is news
speed
articles,
report
if there are
That's the
comments
purpose of
from
it.
public.
That's why we don't
officials,
have no discovery
news has a right to
because of
report on that.
3823. So in essence, I think that's what it sounds like. No
So
discovery.
making this.
Okay, we arrested her and then
motion
we
and
found
this
out later.
and
The
this
only reason we found out later because
private
they
or
arrested her. The
sealed,
only reason the information that they're gathering,
that's
which
just
is
not something
considered
that
evidence
can
of
actually
discovery, that they have now, because they
So
arrested her.
this attempt to sort of
Unfortunately, for
control
the
the
state, they
public
arrested her
discourse,
incorrectly. So all this
it's just
information she's
ineffective
gathering,
and it's
her
also
talking to the officer,
unconstitutional
or
because
talking
it
to
is
other
a prior
people, that's all
restriction
information they're gathering
on.
because they arrested her. And it was an incorrect
The defense
arrest.
is
If they
arguing
arrested her
there
based
is
off
a
assumption, she
constitutional
couldn't go into the apartment. And she can get in an apartment. So
Nobody is
she just
asking
did their
them
work
to
and said,
reproduce
hey, they could have took 2 more steps. What
They've
apartment are you in?
decided
Let me just gauge it.
argument
They didn't do
in the
nothing.
motion.
They didn't leave the apartment. They
decided
thought they had
to
enough
include all of the
BPO
evidence.
and missing proof
That was their
information.
decision.
And any information they found out after that, they can't use
Presumption
it,
is
John.
that it
That's what
is.
this 3023 is codified.
So,
And the news media in our
Judge,
opposition to that
your
motion,
responses,
not the motion to classify,
response
but
to
the motion to exclude
defense
cameras.
argument, that,
One of the
that,
points we made
that
is
would
that
be
a lot of
an
this stuff
issue for
has to do with
a motion
electronic
to
media coverage.
press judge.
It's referring to
Just-
statements made by.
And he,
individuals
and he,
for the
he,
purpose of
he
evidence
took
and
defense
began.
this, I've
So the defense's
There's
position
there's
is
a there's a
they
huge
had to
carve
avoid
out
these
for
things.
officers
We would
acting
push back
in
against because we don't think a lot of the things.
Good faith, right? I think that you're right, that
It was listed in the
Is
order, right? They had the image,
about
they had
whether
it,
electronic
in good faith,
coverage.
it would say the apartment complex. They read the wrong
Some of
order,
those
right? It was listed.
Are
So
even
you're
really
saying officers
connected
around
to
here reading the wrong
the
executive order and people are getting
they're
arrested,
connected
right? There has to be
to
some
what
pushback
officials
to that.
said or did before the
she's
proceedings.
still
And
within
we don't have a dog
200
in that
feet.
fight.
And
We're not
it's
trying to
her
make sure
job,
that was lawful
when you're
or
on
not.
bond,
We're
you
just
have
trying
to
to
know
litigate
what you
should
can and can't
electronic
do.
media
You
coverage
can't
continue.
just try to
And
skirt
so the
it.
defense
You
really
know,
didn't need
this
to
is her
include,
1,
argue. A
2,
lot of the things
3,
they did
4,
include
5,
that again are
6,
public
7,
statements
8
the public has a
assault
right
or
to and have
VPO.
access to,
You know,
and in fact already
you
has
know,
access
if
to.
you're on
There's
bond and
no
you've been
reason
on
to
bond
exclude the
since,
public from seeing those things.
you know how things work.
And
You
for that
can't
argument,
just, well, I guess it's okay if I do,
where the court
How do you
talked
know
about
she's
that
within
very
200 feet? That's what I'm
specifically,
saying. I mean,
saying if the information's already in the
she
public,
is given
then
a
there's not
copy of
anything
the
the court can
protective
do
order. She
by
knows
trying
what
to
she can and
restrict that
can't do.
information.
My question is, how
Again,
do
the
you know
best
she was in
tools
200 feet
available
of
to
the
the
apartment? That's
court
my question.
are the
We don't know
time-honored
that.
things that the
You
court
do not know. Why
can
would you
control.
taking that as solid that
Court
that
cannot
was the
control
case?
public
That's the same
discourse,
officer that said
but it can
she said
control
he was in a
How
apartment.
do you know that she's within 200 feet?
and ensure that that is a fair and
How do you know that? How do you know
that is the
that?
best in this.
I understand that you pulled it up on
Are
the
there any
map, but how
questions
do
on
you
that
know
option?
that she's right there?
Thank you.
Information in the
And
she's in a
before I sit
handicap
down, I
parking
was gonna
spot. I looked at every.
Is there a video there with her in a handicapped
You
spot?
can see the handicap
in the news media today, but I am
the
prepared to
spot
address
that she's in, and you can see where the apartments are. You cannot tell exactly which apartment is the complaint.
And who puts her in the car in the handicapped
The
spot?
complaint.
Is that not sufficient?
Thank you, Your Honor. As I'm going to.
I mean, I think that there's
If I go out to the
more.
address and get a measure to
The motion to
show you
close.
within 200 feet, could that be more information? Because it's short of that, because it's the whole
Yes.
idea of looking at the information.
I mean,
I think that's what I have to do, because it's coming down to 200 feet.
Docket 448.
I don't think it is, because they're saying, it can't be an issue on probable cause, because they're saying she was in 200 feet.
I agree with you. If you come back here and you have some video or
just
some
here at the
picture that
outset,
shows me that
it's something that I'm
handicap
sympathetic
spot
with.
where
And of
she's
course, as I
parked,
was
that
briefing
it's
before on
it's
these
more than
motions,
200 feet,
and she mentioned
then
that
I'd find no problem
drowning in
cause.
a First Amendment briefing. I don't think anyone wants to drown, but if I had to drown in something, I think I would
Thank
drown.
you.
Okay,
Thank
thanks.
you for hearing this whole thing out.
Of course, not a big deal. I appreciate the tenacity. Of course.
The court ultimately needs to make a practical decision about each of these motions in front of it. That's a tough task. And I want to help the court with that.
So do another PR bar.
If the court is going to close or something, the court has to make sure. The court has to explain which interest is in me. It also has to determining that the restriction it's imposing on public access is the narrowest
No,
possible.
it's a deadly conduct, no contact, no weapons, no going to where she lives, the complaining witness, no going to where she works, and then the GPS because of
How do we identify
the
an
prior
interest we
fun,
may leave
I guess, the flight.
exception from this rule of the Public Case Act, and then how do I think that's narrow to ensure that
Let me see.
that I am. I'm grateful, therefore, that the defendant paid a motion.
I don't, hey, do we have a call?
And I'm also grateful that that motion.
Oh, I see it. Okay, so that's an assault? No drugs, no alcohol, no going to La Michoacana, no weapons,
The chief
random testing.
about the kinds of hearings that are presumptively open. This is one of those. There's no reason
And then no contact with a complaining witness or going where they live.
It's not another type of
Or work.
substantive matter that would qualify.
Okay, do you have another arraignment for real?
We start.
Holy moly.
This is
Come on.
Defense also recognizes most of it should be any. The things that they seek to protect are some narrow category. I think where we run into challenges is the lack of specificity. You can get to the specifics, justifying.
Around that way, please.
Then the presumption wins and it stays open. I see in the motion an argument that something about what they call a litany of potentially prejudicial statements may not want to be introduced. Of course, for the court to enter a ruling saying, okay, that part of the hearing will be closed, we have nowhere near the kind of specificity we would need to say what that would even look like. Would there be some sort of short
Right.
colloquy
Good morning, Mr. Wyrick. Sir, you are charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
On March 1st, 2026, in Harris County, Texas, officers were dispatched to a criminal trespass at a Velvet Taco. Complainant, the general manager of Velvet Taco, stated defendant had previously been criminally trespassed from the location.
You say Velvet Taco?
Yes, Your Honor.
Okay.
On this date, complainant instructed defendant to leave multiple times, but defendant refused to comply. Defendant did not make any purchases while inside the establishment and locked himself inside the restroom for approximately 2 hours. Defendant was inside the restaurant, asking the customer for money. Officers observed defendant inside the restaurant and asked defendant and told defendant he was being detained, but he refused to comply and stated he was not going to provide his hands. Officers attempted to detain defendant, but he was physically resistant by swinging his arms and nearly striking officers. Defendant resisting resulted in a physical struggle that moved into a different room. Officers placed defendant off the ground and defendant continued restricting. Officers were able to gain control and place defendant into custody.
I didn't notice that he also has 2 cases. You are also charged with resisting arrest. On that one, you're facing a year in jail and or a $4,000 fine. Okay, Mr. Wyrick, I'm going to find that there's sufficient probable cause to go forward on both of your cases. As a condition of your bond, you're ordered not to go back to the Velvet Taco. You understand? If you go back, I will revoke your bond. I will put you in jail. No more PR bonds. Do you understand? This is not a revolving door. I'm not asking much from you. I want my city safe. I'm going to do everything in my power to protect it. You understand? All right. It's kind of late now. Do we have any lawyers around? You don't want a court-appointed lawyer?
No, I'm just good on that.
Are you sure? Okay, if you have a problem and you want a court-appointed lawyer, just let me know. I'm happy to give you one. We'll give you 30 days. Just, sir, don't go back. I'm not asking much, okay? We're gonna have bond conditions created for you to sign. We'll have you sign a reset. We'll have you sign bond conditions. Once you do that, at that point, you'll be free to go. Okay, sir.
Your Honor, is it any Velvet Taco or just this specific?
Just that one. It's not like, yeah.
Judge, did you want us to go back to bottom of 23?
Who's, can I help you, ma'am?
I'm just a law student. I was just observing.
Oh, okay. Welcome.
Thank you.
Conditions for Simmons in your queue.
All right, Mr. Simmons coming up. There, we're gonna have you sign your conditions. We'll get you out of here. Okay, Veronica, are you ready on Mr. Wilson? All right, come up, Mr. Wilson. Right here. You will now get a GPS monitor on your ankle and you will get a curfew of 9 p.m. to 6 a.m. And you must get a job. J-O-B. 2 weeks. You're to come back here and show me what you have done to get a job. When people have too much time on their hands, they become self-destructive. As you now working on number 16 within 2 years. If I test you and you test dirty for alcohol or dope, I'm going to go bananas on your bond. Do you understand me? No alcohol, no illegal drugs, no driving, no weapons. And if you're out at night, so help me. Do you understand? 2 weeks. I'm going to give you a lawyer today. Well, it's now late. It's now 1:15. I'm going to give you a lawyer when you come back, but 2 weeks. Do you understand?
Jackson?
Weekly. Can you send him home with let's send him home with an application. Oh, make sure, Veronica, on everything, waive all the fees on everyone. Okay. Victoria, we need him to also sign with no driving affidavit before he leaves as well.
You want me to have him come back up to it?
Yeah, I might as well.
He's gonna sign no driving affidavit.
Yes, I have it.
Hey,
Lawrence.
and then we have that one guy back there. Okay, we'll let him out here momentarily, and I think we're almost done. You want to go to the list? Yeah.
Also the two.
5,001?
Yeah.
Nah.
Bottom of the grid.
Oh, he didn't show up. So 5,001.
Bottom of 10, except for Raymond goes over here, first time.
2501.
Same thing for top of 11.
Same thing.
Yeah,
That many, huh?
Bottom
Man.
of 14, same thing.
How many agreements did we do today, too? What the hell? 2501.
All right, page 15, same defendant. Two bonds listed on the.
5,002 on both.
Let me know when you're ready.
All right.
What if that, you have any inmates in the house, what if that, you have any inmates in the house?
Veronica, you're done with Brady? Oh, no, okay, no worries.
Hey, we can bring the other guy out and admonish him with the scram. What was his name? It's Carlos's dude. Carlos's guy. Carlos Rodriguez, the lawyer. It was crap, it was off docket. That's it. Good job. You're the best.
Okay, yes, and you that's put it back on 17.
You get to scram today.
Okay, well, we.
And I just put some new conditions in your future.
Great. Thank you for the help today, by the way.
Yeah, I see in the back, everyone, hey.
Veronica, I think we're close. We're done. We're close to being done. Thank you so much for the help. Don't say that. Careful what you wish for, as they say. All right, home slice, who's next?
20, bottle of 20, set for Raymond, those look here.
2501.
Top of is 21, so what you do with that?
5001. No show.
Top of 22, it's a BBR that's been MIA.
Say it again.
Top of 22, it's a BBR that's been MIA.
Okay, 10,000 and let me see how many times homeboy's been. This is that one. He remember he came with a mom or something. Remember that?
Did you like it?
Oh, I'm gonna go there.
I want to plan clothes. They should run a shop for me. Maybe it's kind of. No.
Okay. 10,002.
Judge,
Yo,
we have a lawsuit.
Yes.
Student here from South Texas who would love to.
yes, yeah. Let me. We're close to being done. That's the last one. All right. Let me say bye. Okay, we're done.